Hello everyone. In the previous video, we briefly discussed about the regional protection of human rights under chapter 8, articles 52 to 54 of the United Nations Charter, which exclusively deals with the matter relating to establishment of regional protection of human rights under various systems such as the European, American, Arab and African institutions. In this presentation, we are going to discuss about the first system, that is the European system on the protection of human rights. The European countries or the Council of Europe, in order to achieve the provisions of Chapter 8 of the United Nations Charter, adopted the European Convention for the Protection of Human Rights and Fundamental Freedoms in the year 1950, shortly called as ECHR. The European Convention for the Protection of Human Rights and Fundamental Freedom is also called as the European Convention on the Human Rights. So, the ECHR was adopted on November 4th, 1950, but it came into force on September 3rd, 1953. Presently, there are 47 contracting states to this convention. The ECHR, that is European Convention on Human Rights, is an international human rights treaty between the 47 states that are members of the Council of Europe. The governments which have signed up to the ECHR have made a legal commitment to abide by certain standards of behavior and to protect the basic rights and freedoms of ordinary people. This ECHR was intended to be a simple, flexible roundup of universal rights whose meaning could grow and adapt to society's changing needs over the time. This convention aims at not only protecting the ordinary people's rights from the abuse by the states, but also imposes the duties or obligation on the state parties to protect the individuals from such kind of abuses. So the scope of this particular ECHR is the ECHR, that is the European Convention on Human Rights. It comprises of totally 59 articles which are divided into 3 sections. So let us have a quick analysis on these particular articles in detail. To begin with, under Article 1 of the Convention, that is the ECHR, the state parties to the Convention undertake to secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of the Convention. So, Article 1 of the ECHR is imposing the obligation on the state parties to the present convention, that is the total 47 states who are presently the members of this particular convention. They all are under an obligation as per the provisions of Article 1 to secure to everyone within their jurisdiction. It means within their national level, within their national territory, these 47 states have to undertake to secure everyone their rights and the freedoms which are enumerated or defined in Section 1 of the Convention. So, Section 1 of this ECHR from Articles 2 to 18 enlists and defines the various number of rights and freedoms which are given to the ordinary people who belongs to this Council of Europe, that is the 47 contracting states. So let us have a quick discussion on what are the rights and freedoms that are recognized under the ECHR. As I told you, Section 1 from Articles 2 to 18 of ECHR guarantees or recognizes various rights and freedoms to the ordinary people. So let us have an analysis on this. The rights and freedoms recognized under ECHR, that is Section 1 from Articles 2 to 18. You could see the various number of rights that are recognized under ECHR. We are very much familiar with these kind of rights because we have already discussed these important rights and freedoms in detail in our previous classes also. The rights and the freedoms that are recognized under ECHR is based upon, or it has been taken from, the International Bill of Human Rights, that is, it is based on the Universal Declaration of Human Rights, ICCPR, that is International Covenant on Civil and Political Rights, and also ICESCR, that is International Covenant on Economic, Social and Cultural Rights. So as we have discussed these rights in detail in our previous class, I am just going to brief about this particular rights and freedoms recognized under ECHR. From Articles 2 to 18, the various rights have been recognized, namely right to life, prohibition of torture, prohibition of slavery and forced labor, right to liberty and security, right to fair trial, no punishment without law, the right to respect for private and family life, freedom of thought, conscience and religion, freedom of expression, freedom of assembly and association, right to marry, right to an effective remedy, prohibition of discrimination, derogation in time of emergency, restriction on political activity of aliens, prohibition of abuse of rights and limitation on the use of restriction on rights. So these are some of the very important rights and freedoms that are recognized under the ECHR, that is European Convention on Human Rights. One of the main significant feature of this ECHR is it not only recognizes or enlists the huge number of rights and freedoms to its ordinary people, but also the ECHR has certain enforcement machinery for the purpose of the proper implementation of whatever the rights and freedoms that are recognized in ECHR. So therefore, it is very, very essential for us to know what are those implementive machineries or the enforcement machinery which have been working for the proper implementation of the rights and freedoms recognized in the ECHR. The enforcement machinery for the observance of the protection of human rights under the European Convention on the Human Rights is, the first and the very important thing is the European Commission on Human Rights, which was set up in the year 1954. And secondly, the European Court of Human Rights, which was set up in the year 1958. The European Commission of Human Rights and the European Court of Human Rights, along with its Committee of Ministers of Foreign Affairs, they are working within this particular framework of the Council of Europe. So, according to the provisions of the ECHR, the implementive mechanism or the enforcement mechanism or the machinery for the observance of the protection of human rights are, the first one is the European Commission of Human Rights and the second one is European Court of Human Rights. So we are going to discuss this implementation mechanisms for the protection of the human rights or whatever the rights and the freedoms that are recognized in ECHR. So let us discuss about the first implementive mechanism or the enforcement machinery, that is the European Commission of Human Rights. Section 3 of the ECHR provides the provisions relating to European Convention on Human Rights. The Commission, that is ECHR, again the European Commission of Human Rights, consisted with the number of members who are equal to that of the high contracting parties. Please observe, the total number of members is not fixed in section 3 of the ECHR, but section 3 of the ECHR, it says that the commission consists with the number of members, the total number of members to this commission must be equal to that of the high contracting parties. So the high contracting parties, in the sense the 47 states who are the members of the Council of Europe, they are called as the high contracting parties. So, as per the provisions of section 3, the commission consisted of a number of members. That number of members must be equal to that of the high contracting parties. The high contracting parties are totally the 47 states. However, the commission did not have two members who were the nationals of the same states. There can be less than 47 members, but it cannot be more than 47 members. So therefore, there cannot be two nationals from the same state. The members of this commissions were elected by the Committee of Ministers by an absolute majority of the votes from the list of names drawn up by the Bureau of the Constituent Assembly. The members were elected for a period of 6 years. However, they are entitled for re-election. The members of the commission sit in the commission in their individual capacity. Even though the members are represented by the high contracting parties, the members are exercising their powers or the responsibilities on their individual capacity. Therefore, the high contracting states or the parties are not liable for whatever the act that has been exercised by the members of the commission. The individual member will be held responsible or will be held liable because they sit on the commission in their individual capacity. So coming to the functions of the European Commission on Human Rights, the main function of the Commission was to receive the complaint from any high contracting party through the Secretary General of the Council of Europe for the breach of the provisions of the Convention. So the main function of the European Commission on the Human Rights is to receive or accept the complaints which are made by the high contracting parties through the Secretary General of the Council of Europe for the breach of the provisions or any provisions of this convention. The Commission could also receive the petitions from any person, non-governmental organization or group of individuals who are claiming to be the victims of the violation of the human rights by one of the high contracting parties. If any high contracting parties have violated the human rights or violated the provisions of this convention or violated or abused the rights and the freedoms that are recognized under this convention, under such circumstances, any person or non-governmental organization or group of individuals can make a petition to the commissions, and the same petitions can be accepted by the commission also. However, the individual could make the petition if the individual person on his personal capacity, if they wants to make a petition to the European Commission on Human Rights, they have certain conditions that has to be fulfilled. The individual could make a petition only when The high contracting party had declared that it recognized the competence of the commission to receive such petitions. A very important thing you have to remember, that is, an opportunity has been given the individuals to make a petition only on the condition that the individual can make a petition only when the high contracting parties had to declare. For example, if an individual is filing the petition against his high contracting party, then that high contracting party has to declare that it will recognize and accept the competence of the commission to receive such petitions. It means this commission, that is European Commission on Human Rights, they have the competence to entertain the petition that has to be declared by the high contracting party. Then only the individual can make a petition to the commission. So, the individual could make the complaint only against those state parties who have declared that they recognize the competence of the commission. For example, there are totally 47 high contracting parties to this convention. Out of this, if any number of countries out of 47, if any number of state parties, they have declared that they recognize the competence of the commission, then only under such circumstances the individual can make a complaint against only those states who have declared the competency of this particular commission. The remaining countries who have not recognized the competence of the commission, they cannot make the petition for the abuse or violation of their rights to the European Commission on Human Rights. Therefore, it is implied that the individual petition is optional. Coming to the very important aspect, that is expiration of the commission. When this commission was established, the commission used to get the huge number of application on the abuse of the violation of the rights and freedoms that are guaranteed under the European Convention on the Human Rights, or violation of any of the provisions in the ECHR. And as the number of application was increasing before the commission could not exercise its function more effectively and efficiently. So as a matter of this, the additional protocol of number 11, that is the protocol number 11, which came into force for the purpose of restructure the control machinery of the convention in an efficient and effective manner. So therefore, the Council of Europe adopted the optional protocol or additional protocol number 11, which came into force on November 1st, 1998, which made a provision for the expiration of the commission. So as per the provisions of protocol number 11, the European Commission on Human Rights has been expired. So the convention ceased the operation of European Commission on Human Rights, which came into operation from 31st October 1998. The protocol number 11 provides the provisions for the expiration of the commission. Hence, the European Commission was replaced in the year 1998. On the place of this European Commission on Human Rights through the protocol number 11, which created for the full-time European Court of Human Rights. So before 1998, the European Court of Human Rights was not a full-time authority. It was only a part-time, or it was a temporary basis. It was working as a temporary basis. But Protocol number 11, which repealed or replaced the European Commission on Human Rights, and it created the full-time European Court of Human Rights for the purpose of efficient and effective protection of human rights as per the provisions of European Convention on the Human Rights. So from 1998 onwards, there is no implementive mechanism or the enforcement machinery which called as the European Commission on Human Rights. It was ceased to be operated on 31st October 1998, and it was replaced by the full-time European Court of Human Rights. So this is regarding the first implementive mechanism or the enforcement machinery, that is European Convention on Human Rights. In the next presentation, we are going to discuss in detail about the full-time European Court of Human Rights. Thank you.